Blended families. This is a short video showing you why not having an estate plan in place when you are part of a blended family can have unintended but very serious consequences. My name is Mona Gazar and I'm an estate planning attorney here in Norman and owner of Unity Legal Services. There are several categories of people who may need estate planning more than others, such as people who own real property if they want to avoid probate, single persons, parents with minor children, and of course blended families. If you'd like to learn more about probate, what is and how to avoid, revocable trusts, power of attorneys, guardianships, please be sure to sign up for our free estate planning webinar. But for now, let's talk about blended families. The best way to explain why blended families need something in writing is through a scenario. So here it is. So here is our blended family. We have wife at her second marriage and then husband, let's say, at his third. Wife has a daughter from her first marriage. Husband also has a daughter with his first wife. Together they have a son. Let's see what happens if the wife dies first and there is no estate plan in place. For all joint tenancy assets such as their home, or they may have bank accounts, cars, husband receives everything. As we know, when one joint tenant dies, if it's with the right of survivorship, the second tenant receives everything. You see, we faded out the kids because they're not to inherit any joint tenancy assets. However, if the wife has separate property from her first marriage or from before marriage, let's say a home or life insurance investments, where do they go? It all depends. If she has beneficiaries listed, if they have to be probated, and so on. Similarly, if the husband dies first, all joint tenancy assets go to the wife. Again, the kids do not inherit anything. Is that what they would have wanted? We don't know. If that's not what you want, you have to make sure you have some plan in place. So let's see what happens when the wife dies last. The husband predeceased some time ago, let's say. There was no estate plan. The wife automatically became the sole owner of their joint property. Now, upon her death, what happens to these assets? As you can see, only the wife's children will inherit, their common son and her daughter. His daughter, the husband's daughter, will not inherit. In Oklahoma, stepchildren do not inherit unless there is something in writing, like a will or a trust or an alternative method. Similarly, if the husband dies last, wife predeceased, he was the sole owner. Now, wife's daughter does not inherit, only his children. Is this what they would have wanted for their kids? Maybe, maybe not. But if you do not want this to happen to your family, where you leave kids out, please make sure you get an estate plan in place. So let's talk about unintended consequences when we have a blended family with no estate plan. Children and grandchildren may receive no inheritance. As we saw in this situation, the wife's daughter does not inherit. If she had kids, her kids do not inherit either. Even though the family had a close relationship, the wife's daughter will now not inherit because there is nothing in writing. Estranged stepchildren now inherit. Let's say husband's daughter was out of the picture for a long time, never kept in touch. Well, she will now inherit. You may not want that to happen. Expensive estate administration. If there is real property in the estate, the chances are that you need a probate. A probate can cost many thousands of dollars and take a long time. High risk of expensive conflict. As you can imagine, in this situation where wife's daughter does not receive anything, she may not be happy. She may try to sue someone or contest the proceedings, which can lead to thousands of dollars in court fees. Relationships ruined. Similarly, even though the family was close, the kids got along, now one of them does not inherit. That may just completely ruin their relationships. Solution: get an estate plan and talk to your family about what you want to happen when you pass. So some of the pros of a last will and testament are that you can provide for a distribution. You can include your stepchildren. The problem is if you only have a will, you will probably have to go through probate when there is real property involved. A revocable trust has some more pros because it also includes incapacity planning. You can provide for a gradual distribution and so on. There are some alternative options to a revocable trust and a will, and that's a transfer on death deed, payable on death designations for your bank accounts and other financial assets. Joint tenancy is not a good idea necessarily for estate planning purposes. So make sure you fully understand the pros and cons. Lifetime gifts, you can start giving things away. You may not want to do that because you cannot take them back. There may be some tax consequences and so on. So thank you so much for watching. I hope you found this video to be informative. Please remember that you have the option to sign up for our free estate planning webinar, where you can learn a lot more about these concepts and more. Give me a call, 405-857-8231, or send me an email if you have any questions or if you would like to schedule an appointment. Have a great day.